Good morning, Year 12, and welcome back to what would have been school if we were still there. I hope you've had a restful 2 weeks. I hope you've not done too much. I hope you're giving your brain a rest, because even though we haven't actually been at school, the kind of work I've been setting and the kind of things that I've been doing personally for you to do will still tire you out, and was still the amount of stuff that you would have been doing at school anyway. So I hope you've had a rest. I hope you've had a chance to let your brain kind of reset, and I hope you're ready to continue learning about stuff for school, even if you're not there. Today I'm going to be looking at this PowerPoint here, comparing the US and the UK Supreme Courts. On the Supreme Court section, this is the last bit we have to do about the Supreme Court itself. We're going to move on to civil rights, but I'll talk about that later on. So here is the PowerPoint presentation that you will have got, and as it says on the title and as it says on the name of the file, we are going to be comparing the US and the UK Supreme Courts. You obviously have to do this because as part of one of your questions, it is a comparison, and you have to be able to talk about both of them and talk about both of them at the same time and show why one is different and why they are similar as well to each other. So there's a few ways of comparing the US and the UK Supreme Courts. I'm going to go through 3 out of the 4 of them. The other one is quite long, and it's also something that you've done before with the UK Supreme Court, so I'm going to give you the chance to do that yourself and make your notes based on what you've read, just to show that it's not just me that's doing all the work, and that you can compare using the prior knowledge that you've got. So the first thing that we're going to look at to compare the US and the UK Supreme Courts is the origins of the US and the UK Supreme Courts. So as we've learned in both of these, and I'll start with the US, I'll always start with the US because it's on the left-hand side. The US Supreme Court came into being in 1787 through the Constitution. Specifically, there is a quote from Article 3 here: "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as such as Congress may from time to time ordain and establish." So essentially, it established a Supreme Court that was above every other court in the land, inferior courts, and that Supreme Court can rule on some of the cases that come from the inferior courts. What a lot of people don't know about the US Supreme Court is actually it didn't have its own building until 1935. It moved around. It started out in New York. It ended up in Philadelphia at one point. It moved around the country. Eventually, it gained its own building in Washington D.C. But all throughout this time, it wasn't seen as inferior because it didn't have its own building. It was still seen as the entirely separate from Congress and separate from the rest of the lawmaking. And the fact that this was adhered to shows the kind of distrust in the fused powers that was still typical of government structures in Britain. Don't forget, the Constitution, the Bill of Rights as well, were all written as a reaction to British control of America. And so what they are doing with with removing these fused powers that they saw Britain as having, because obviously the highest court in Britain at this time was in the House of Lords, what they're doing is they are going against what Britain already had, and kind of reacting against Britain and trying to be as separate as possible. In contrast, in the UK Supreme Court couldn't be more different. It came into existence as a result of an Act of Parliament in October 2009. At this time, it replaced the Appellate Court in the House of Lords as the nation's highest court. The Appellate Court had similar kind of powers to the Supreme Court, but it wasn't seen as separate because it was part of the House of Lords, and it was ruled by lords from the House of Lords, and so it wasn't separate from the lawmakers because the House of Lords is a house of legislature. So therefore, it was never seen as separate. And at the same time, so not afterwards, at the same time in 2009, the Supreme Court was moved out of government buildings and given its own building on the other side of Parliament Square, and so it is politically and structurally separate from Parliament itself. And so therefore they could claim that the Supreme Court had been removed from the political structure of Britain at the time. So as you can see, aside from the 250 or so years difference that exists between the two courts, the actual principle of the courts is quite similar, but the execution is totally different. Next, I'm going to talk about the appointments, the membership, and the tenure of the justices. So as we know, in the US Supreme Court, there are 9 members. They are nominated by the President, they are confirmed by the Senate, and they serve for life, or during good behaviour. We'll come to that in a second. 3 of the 9 member courts are female. One, Clarence Thomas, is African American, and another justice, Sonia Sotomayor, is Hispanic. So there is a breadth of gender, and there's also a breadth, so to speak, of minorities in the US Supreme Court. There seems to be an opportunity for self-interested presidents to nominate and self-interested senators to confirm justices who share their political and particular judicial philosophies. So you'll find that Republican presidents and Republican senates will nominate and confirm justices that are strict constructionists, because that kind of aligns with their political leaning. And that kind of opens up the question as to whether the Supreme Court is a political thing or whether it is removed. And we're going to come to that when we talk about judicial independence. And finally, the only way a justice can be removed is through impeachment. And this has happened once with Samuel Chase in 1805. That's the only way. They can retire, they can choose themselves to step down, but generally the only way to get out of the US Supreme Court is by dying. And so therefore this kind of cements their tenure and means that the justices on the Supreme Court can act with independence, because they can't face retribution from the President or from Congress if they don't agree with what they did. Contrastingly, with the UK, there are 12 members of the UK Supreme Court, and they are nominated by an independent body, the Judicial Appointments Committee. One of those people on the Judicial Appointments Committee is a Lord. The rest of them are selected to be independent, and the idea is that the political leaning of the government at the time and the political leaning of the House of Lords is removed from that committee. The judges in the UK must retire at age 70, and 2 of the justices are female, Lady Black and Lady Arden, and there have been none from ethnic minorities in the history of the Supreme Court, the 11-year history. This kind of fits, though, with the background of many of the UK's judges anyway. I think, off the top of my head, only about 14% of UK judges come from an ethnic minority, and it's only about 25 to 30% are female in the justice system in Britain. So you could argue, and I'm not saying that this is right, but you could argue that it reflects the background and the minority percentage of the court system in Britain itself. However, you could then also argue that doesn't represent the background and the minority structure in Britain. So, you can argue that both ways. What you can't argue about is how you can be removed from office. To be removed from office in Britain, both houses of Parliament have to address the monarch, who can then remove the judge. So you have to have both houses of Parliament that come together, agree that this person has acted in a way that is against what the Supreme Court should be, and then the Queen or King has to remove the judge. And that's kind of a ceremonial thing. Once the two houses have come together, it's kind of done at that point. So another thing that kind of separates the US and the UK Supreme Courts is their powers. I should say the one significant power of the US Supreme Court, let me just change that here now, is judicial review. Okay, judicial review wasn't written into the Constitution, but it was found by the justices through Marbury versus Madison, which we've already talked about. And this is where the first federal law was found unconstitutional, and this kind of set the precedent for what the US Supreme Court would do in future. The court has a fundamental effect on the whole range of policies, leading to it being dubbed the third house of the legislature. It often calls into question a lot of laws and a lot of things that the Congress and the President do, and use judicial review to check those things, and therefore it's kind of been dubbed the third house of the legislature, because they have the power to take these laws out or make these laws different. In the US as well, the Supreme Court is in all matters of rights and liberties the supreme authority. It's the highest thing in the US, highest piece of authority on rights and liberties. Nothing is higher, not even the President, and so the Supreme Court holds that kind of sovereignty over the rest of the US. In contrast, in the UK, we only have 10 years of evidence really anyway, or 11 years of evidence anyway on the UK Supreme Court, so we can't come to many conclusions about how effective it is. It's starting to become a political actor. If you think back to the proroguing of Parliament last year, they declared that was unlawful, and Parliament had to go back and sit after that. But according to the website, the powers that it has include hearing appeals on arguable points of law of the greatest of public importance for the whole of the United Kingdom in civil cases, and for England, Wales and Northern Ireland in criminal cases. So it doesn't actually acknowledge its political stances. It shouldn't be political, but it does call into question some of the things that happen in Parliament. It does also state on the website that it cannot overrule the UK Parliament. It can only interpret the meaning of parliamentary law, and that's why it has this political leaning, even though it doesn't kind of say it does. In the UK, at the moment, until at least the December the 31st this year, it also has to answer to a higher authority. The European Court of Human Rights in Strasbourg has the highest amount of authority in Europe on a lot of cases, and when the Supreme Court is ruling, especially on things like the Human Rights Act of 1998 and things like that, it has to look at what the European Court of Human Rights says and go with that. Whether this will change after December the 31st this year, we will see. It's hard to know what's going to happen, especially because of current climate. There is no negotiation, or they're on about restarting negotiations with Europe at the moment, but at the moment there's nothing. So we're kind of in this limbo where we don't know if we're going to have to answer to the European Court of Human Rights after December the 31st. For the purposes of your exam questions are written probably by now. So if you get asked about the UK Supreme Court, they won't spin it to do with Brexit, and they won't spin it to do with whether we have to go with the European Court of Human Rights. But it's worth knowing that it was, and currently is. So it's worth knowing that it has been, and it's a comparison point that over the first 11 years of the UK Supreme Court, it did have to answer to a high power. And to be honest, I don't think that it will matter in your exam, but you can use it as a case study to show the weakness of the UK Supreme Court in comparison to the US Supreme Court. At the bottom there is a power that both courts share, and that is the power over the executive branch. The US Supreme Court can declare actions unconstitutional, and therefore have them removed. And the UK Supreme Court can declare actions to be ultra vires, or beyond legal power or authority. We did talk about that, so if you're not sure what that means, or if you can't remember what that means, go back and look at your notes, because we did talk about it. So when you look at the PowerPoint on the system, the next few slides after this will be on notes for about independence. We spoke about judicial independence and judicial neutrality with the UK Supreme Court at length, and this should fit well with your prior knowledge. Now you need to look at whether the US Supreme Court is independent and neutral, and you need to compare that with the UK. So try and note these things down as the way you've done the rest of this presentation. I would suggest doing like having a piece of paper that's split half and half, US, UK, something like that, but do it the same way so you've got continuity when you revise. The last thing I want to say is kind of a look at what's coming next. We are going to do civil rights next, and I've not uploaded that to the VLE yet because I need to go through it and make sure that it's all correct and make sure that it works and etc, etc. So once that is done, I will upload it to the VLE as soon as possible. But for now, a lot of you have still got the 3 exam questions that you need to send me, and also you've got the notes that you've got to make off this. I will continue making videos like this as if we're having lessons each week, so you get some idea of a timetable, and I still want to do it Monday, Wednesday and Friday. Now, I am aware that today is Tuesday. I had a day where I spent marking stuff and getting back into the swing of things and looking at things that the school had told me to look at, and so I didn't do a video yesterday. Just on the subject of marking, I have marked some people's things already. If you've not had your thing marked yet, that's because I've not got to it yet. I'm currently doing my emails first, and so if I've got to you and I've sent you the feedback, fantastic. If you've got any problems with that, let me know. If I've not got to you yet, it's because I've not got there yet, but I will get it done over the rest of this week, so don't panic. And if I then say I've marked everything that I've got, I think, and I've not marked yours, you might need to point me towards where you've uploaded it, because a lot of people have uploaded it in different places. So it may have slipped through the net and I've not found it. So you might need to tell me if I say I've marked everything and yours hasn't been marked yet. But what I'm trying to say is yours will get marked eventually. If it's not been marked yet this week, I will probably have done it by the end of this week, but I will let you know, and I'll continue to kind of point you in the right direction of where I am as well. I hope everyone's staying safe. I hope everyone's staying well. And as of this lesson, thank you for listening for the entirety of this video, and continue to keep up the good work. Generally, you are doing really, really well. So thank you for that. See you later.